Welcome back to Crypto Law TV. I'm John Deaton, your host and the founder. Today's topic is probably the most talked about and discussed and tweeted about topic of all topics related to the SEC v. Ripple case. And what is that? Settlement. And is a settlement in the works? What is the likelihood of a settlement? And all of those issues that are burning as we're getting ready for what potentially could be the last biggest bull run of crypto's next cycle. Recently, BitBoy, who has one of the largest, if not the largest following in all of crypto land, as he says, made a bold prediction. And that prediction was that settlement discussions are in the works. And in fact, it's a done deal and that it will be settled by the end of September. And a lot of people have challenged that because I have filed a motion to intervene and I'm a litigant in the case. A lot of people have asked me, what do I think about that? And there's been a lot of confusion because a lot of people don't believe that a settlement is in the works based on the litigation that's taking place. For example, there was a hearing, motion to compel the documents related to Bitcoin, Ethereum, and XRP, and the SEC's invoking the deliberative process privilege. There was a hot, contested hearing, and we know that there's a motion to compel that's been filed by the SEC for the Ripple Slack messages and text messages. And then we've learned that Ripple apparently may have recorded some of their staff meetings, and the SEC wants possession of all of those tapes. And we know that there's been this battle back and forth in the case. And many people think, well, that just shows you that it's not going to be settled because look at how they're highly contesting every issue. And so the purpose of this video is to hopefully dispel some of that confusion. And you cannot let what's happening in the courtroom confuse you as it relates to settlement. So is it possible that BitBoy's prediction or anyone else's prediction that a settlement is imminent, can that be accurate? And the answer is sure, it could absolutely be accurate. Do I know for sure? No. Do I know what process that has taken place? No. One thing I can tell you is that in high stakes litigation such as this, you have two teams for each side. So Ripple has two teams and the SEC has two teams. One team is a trial team. And at the SEC, Jorge Tenrero is the captain of that team. All right. And on the Ripple side, you have Solomon and you have Andrew Sresny and you have Kellogg, and they are the co-captains of the Ripple trial team. But each side has another team, and that's the settlement team. For example, have any of us seen Mary Jo White, who is on Ripple's legal team, who is a former SEC chairwoman? Has she been litigating any of these issues? Of course not, all right? Because she's not a soldier, she's a general, all right? On the SEC side, you have Gary Gensler, the director of corporate finance, or any other person that Gary Gensler would designate to handle settlement talks. So you have two separate teams because you don't want Tenrero or Sullivan both trying the case and trying to settle the case because emotions get in the way, right? You're in there, you're contesting issues, you're challenging each side. Each side is claiming that the other side is hiding documents and withholding evidence. But then to have those same people try to negotiate a settlement, emotions get in the way, hurt feelings get in the way. You can imagine, Jorge Tenrero might come in and say, I can't believe that you accused me of withholding evidence or documents. Or it could be vice versa. The Ripple attorney could do the same. So you create the separation of trial versus settlement. And the trial attorneys are designated. You go into court and you fight, and then you report back. So they were fighting over the deliberative process privilege, right? Jorge Tenrero went back and he's reported to the settlement team that, okay, the judge is doing an in-camera review. If those documents are hurtful, as I suspect they are, to the SEC's case, then Jorge is going to report that back. Because if Ripple gets their hands on those documents, that gives Ripple more leverage in the negotiation process. So while Tenrero and Sullivan are in there fighting each other tooth and nail, you may have Mary Jo White and Gary Gensler sitting back having cocktails at $1,000 luncheons, discussing the potential for settlement. And so don't let what's happening in the courtroom confuse you or discourage you that a settlement's not in the works. You know, is it going to be by the end of September? I don't know. BitBoy's guess is as good as mine, as good as anyone's. Do I think, if you ask me, do I think it's going to happen that quick? Probably not. Okay. And I'll tell you why in a minute. But I want to share with you, in this type of litigation, that's how you separate and you keep the emotions and the hurt feelings that take place between two combatants. All right. If you look back at even the Civil War or any war, you had battles going on, you know, while the generals were discussing settlement, surrender, whatever it is. And sometimes the soldiers are the last to know. For example, before I opened up my own law firm, I was that trial team guy. I was that, you know, dog in the fight, if you will. And my boss would be the settlement authority. And my instructions were to go in and win, go in and fight, go in and battle. And so motions to compel, emergency motions, sanctions, whatever it took to win, if I thought it was legit, that's what I would file. In the meantime, he's talking to the general counsel of General Electric or Halliburton about, you know, settling 20, 30, 40 cases. And there was one time I remember I was just in an opening statement. We selected the jury. I gave an opening statement. I'm going over the direct examination of my first expert witness, and I'm prepping and I'm working all night. And I go in the next morning after working all night, and I find out from the defense attorney that the case is settled at 10 o'clock the night before. Right? My boss didn't even tell me that a settlement had taken place. Now, of course, I'm a little upset, but the point I'm making to you is that there's a very distinct difference between what's happening in the courtroom and then what's happening in the boardroom. So listen, is this case in the middle of a settlement talks? Is this case going to settle in a matter of a few weeks, or is it going to go the full distance through the courts? Well, you know, Gary Gensler made a prediction when he was at MIT. And let's look at what that prediction was.
The token XRP and whether I think it's a non-compliant security. I've spoken publicly. Yes, I do think it's a non-compliant security. But this will not be resolved just by the Securities and Exchange Commission. It will be resolved by some courts, whether it's appellate courts or the Supreme Court. So what I believe is just that. It's a belief.
Now, as you could see from that clip from Gary Gensler, he said that although he thought XRP was a security in 2018, the courts would decide, right? And whether that is the appellate court or the United States Supreme Court, someone other than Gary Gensler was going to decide. Now, the difference is Gary Gensler was not in charge, okay, of the SEC at that point in time when he made that statement. But I think that we have to be prepared that it's possible that the SEC is taking that approach. Now, what's going to cause a settlement? What's going to cause a settlement is when you make the SEC scared that a loss could have permanent damaging effects on the SEC's ability to move forward. The precedent that a loss would have, for example, by the fair notice defense, it's huge, got huge implications. But right now, although Ripple has been successful at some motions and some documents and all of those things, the SEC filed a motion to strike the fair notice defense. Okay, now, if the SEC wins that motion, that means the fair notice defense is out of the window, right? Dead on arrival. And Ripple would lose huge amount of leverage. Now, if the SEC loses that motion to strike, which I predict they will and that they should, that doesn't mean that Ripple wins. That only means that Ripple can move forward and argue the fair notice defense to the judge at a summary judgment or to the jury at a trial. Okay, so once the SEC loses that motion, now they're going to be a lot more scared than they are today. See, right now, the SEC can claim that they believe the judge will strike the fair notice defense. Once the judge gives a ruling that the fair notice defense can be argued, now the SEC is going to take a step back and then say, wow, if Ripple wins this case based on fair notice, that puts us out of business related to all the other cryptos or every other crypto except for a new ICO. Okay. And with that kind of fear, with that kind of realization, then maybe, just maybe, Gary Gensler will revisit his position where he said the courts will decide. But I think it's going to take some ruling to cause the SEC to become more scared, if you will, and fearful that they're going to lose. I mean, listen, look at what Gary Gensler's mindset is. Okay, in a recent video, look what he said.
Now, over the years, the SEC has brought dozens of cases, many of them during my predecessor's time. I've only been here 3 months. And yet, having brought dozens of cases, we haven't lost a case.
He literally said that the SEC, as of yet, has never lost a case. So if you go into the court thinking, well, the court's going to decide it, and we've never lost a case, if that's your mindset, you have to be prepared for the long haul, okay? Until you make the SEC fear for their self-preservation, if you will, because they lose the fair notice defense, that is incentive for them to come to the table and to settle. And finally, we got to talk about just for a second what a settlement means, okay? Because I have to tell you that a settlement where the SEC simply says, Ripple, you pay a fine of 25 million or 50 million, whatever it is, for sales of XRP between 2013 and 2017 because it was an unregistered security, and we will settle this case. If that's all that is said and done, and there's no additional clarity, there's no declaration by the SEC that XRP today is not a security, that's not a settlement that provides clarity. That's a slap on the wrist. Okay, does that mean Coinbase and Kraken and other exchanges are going to immediately relist XRP? Are they going to relist XRP absent some type of determination or clarification that they can sell XRP moving forward and not have any issue with the SEC? They're going to need that. Whether that means the SEC makes a declaratory statement that with this settlement, XRP moving forward is going to be considered a non-security based on the decentralization. It would require something similar to what Bill Hinman did for Ether, okay? Or it would be, we settle with Ripple, here's your slap on the wrist, and we're going to issue a no action letter that we publish that we are not going to go after the exchanges for selling XRP, okay, moving forward. If there's something like that with the settlement, then great. There's clarity and we move forward. But if it's simply we're going to go back as though we never filed the lawsuit and you pay, 50 million for these previous sales in the earlier years, and we're not going to say anything else, I don't know if that is going to be enough incentive for Ripple to settle. So for all of you out there, this is what you do. Just like I take on every case, I'm going to assume that the case is going to go to the end. In this case, that means probably summary judgment or declaratory judgment. Okay, and hope for the best. I'm not going to, assume that the case is going to settle in 2 weeks or 3 weeks, because then all you're going to do is be let down. All right, I'm going to hope for it, but I'm going to hope that it comes with real clarity if there is a settlement. Okay. Now, other than the motion to strike the fair notice defense, there is another motion that could affect this case and that could affect settlement. And that to me is a motion that is near and dear to my heart, because that is the motion to intervene or at least be granted amicus status with participatory rights to XRP holders, to the 19,000 plus people that we have knocking on the court's door. If the judge allows that motion and allows us to participate, that's going to create a dynamic for the SEC where they're fighting against Ripple, right? But they're also fighting the very people that they allegedly protect. They're fighting against the very people that they allegedly filed the case on behalf of. So if XRP holders are granted intervention or amicus standing with participatory rights, I've said it before, I've made these analogies of war. Who better to win a war than an army led by a Marine? Thank you. See you next time.